Thank you, Mr. Chairman. H.R. 2250 is a compromise. Like any compromise, the language of the EPA Regulatory Relief Act isn't what I might have done if I were acting alone. However, this language brought together a group of legislators from both sides of the aisle with a reasonable approach and reasonable language. And I am proud to be able to carry and defend this bipartisan compromise language. This bill has 116 co-sponsors, of which 24 are Democrats. We have hundreds of letters of support from businesses, unions, and trade associations. Boiler MACT and Cement MACT are complex areas of law and regulation. We're talking about hundreds of pages in the Federal Registry of very complex rules. Businesses need certainty, and they need to know we're going to get the rules right. These bills simply give us sufficient time to get the rules right when imposing such complex, expensive, comprehensive rules on businesses that employ thousands of hardworking Americans. Particularly in this economic environment, we need to be sure the rules are right. As EPA told the Court last December on Boiler MACT, investments required by these rules are irreversible. For those businesses that decide to stop producing their product at a particular location, the job losses are also irreversible. Let me tell you why this matters particularly to me and to my constituents. We've had a number of businesses and other entities testify at various hearings that these pending rules on Boiler MACT and cement would negatively impact them. 4 of these companies employ people in the 9th District of Virginia: Midwest Vaco, Celanese, Titan America, the parent company of Roanoke Cement, Rock 10. Many others across the 9th District are also affected, and of course the United States as a whole. These are real people, and these are real jobs that are on the line. The purpose of H.R. 2250 is to clarify Congress's intent that the EPA must set standards that are actually achievable by real-world units. And it's interesting when you look at the language of the actual underlying bill, and I quote, "Emission standards for existing units in a category may be less stringent than standards for new units in the same category, but shall not be less stringent than the average emissions limitation achieved by the best performing 12% of units in the category, excluding units which first met the lowest achievable emission rates 18 months before the date such standards are proposed or 30 months before the date such standards are promulgated, whichever is later." We're at a situation where we're looking at rules that only apply to the 2%. I don't think the original intent was that you go from 12 to 2. I think 12 was put in there for a reason. It may not be that you can't go to 10, but I think from 12 to 2 is too big a spread. I don't think the EPA is applying rules that meet the original intent of the legislation. I think this new legislation is necessary, and I ask that you pass both bills.
This time I recognize the gentleman from Louisiana, Mr. Scalise, for a 3-minute opening statement.